Rape is one of the most serious offences in Malaysian criminal law. Yet, in many rape trials, the real issue is not whether sexual intercourse occurred, but whether it occurred with consent. In this presentation, we will examine how Malaysian courts interpret and apply the defense of consent in rape cases. Our discussion is based on analysis of 25 cases in Malaysia. We have structured our discussion around 4 objectives. First, how consent is defined under Malaysian criminal law. Second, how the defense of consent operates in practice through statistical analysis. Third, how judges reason when consent is disputed. And finally, what recommendations can be made based on observed judicial trends. Let's begin with the legal foundation. Ms. Nazreen, when an accused raises consent as a defense, how do Malaysian courts understand the meaning of consent?
Okay, so under Malaysian law, rape is governed by the section of 365 of the Penal Code. Once the penetration is proven, the central issue becomes whether the sexual intercourse occurred without consent. And consent also is not defined as a mere submission. Courts consistently hold that consent must be free, voluntary and informed. This means that the complainant must genuinely agree to the act without fear, coercion, deception and also incapacity.
How have courts drawn the line between consent and submission?
Okay, so Malaysian court have clearly distinguished these two. For example, in the case of Muhammad Safri bin Ma'aruf against public prosecutor, where the court dismissed that the stress that submission caused by fear doesn't amount to consent. And similarly, in the case of public prosecutor against Abdul Rahman bin Muhammad, consent obtained under fear or misconception of fact was held to be legally invalid under Section 90 of the Penal Code. The courts also have rejected the idea of silence, delay reporting, and also the absence of physical resistance automatically indicates consent. Instead, they assess the totality of circumstances, including the mental state of the complainant.
So consent is treated as a legal concept rather than a factual claim.
Yeah, that's true. Malaysian court treat consent as a legal standard, not merely as an assertion by the accused. This strict approach reflects the seriousness of the offence and need to protect the sexual autonomy.
Now, we move on with our second objective. Mr. HAIRIL,
yes.
Your role focuses on numerical and statistical findings. So what does the data actually show?
Okay, our study analysed 25 cases in total from 1965 until 2024. Statistically, the defense was successful in only 8 cases, which carry out only 32% of the total cases, and the other 17 failed, which resulting in failure rate of 68%.
Okay, so that suggests that consent is rarely accepted. Why is that?
Okay, the data shows that while consent is frequently raised, courts apply a high evidentiary threshold. Consent tends to fail where there is evidence of force, fear, deception, incapacity or statutory protection. We also observe that the High Court decided the majority of these cases, amounting for about 72% of the dataset. This indicates that factual evaluation and credibility assessment occur primarily at this level.
Was there any change over time?
Yes, a very significant one. In earlier cases from 1960s to the 1980s, acquittals were more common due to strict corroboration requirements. However, in modern cases from 2010 onwards, the success rate of consent-based defences dropped sharply to about 10%. This reflects advance in forensic evidence and a more victim-sensitive judicial approach.
So, for objective number 3, Ms. BAZLA, beyond statistics, how do judges actually reason when consent is raised?
Judicial reasoning in Malaysia rape cases show a strong emphasis on credibility, consistency, and objective evidence. Court closely examine inconsistencies in testimony, medical findings, surrounding circumstances, and explanations for delayed reporting. While corroboration is no longer a strict legal requirement, it still plays a practical role in judicial assessment.
Are there patterns in when consent succeeds or fails?
I think yes, consent is most likely to succeed in cases involving evidential uncertainty, such as conflicting testimonies of lack of corroboration. However, in categories involving force and fear, deception or incapacity, and statutory rape, the defense almost always fails. Court consistently hold that consent in these circumstances is legally invalid.
So does this approach raise any concern?
While the court's cautious approach helps prevent misuse of consent as a defense, there is concern that continued reliance on physical evidence or behavioral expectations may disadvantage some complainants. Nevertheless, overall Malaysian courts strive to balance the presumption of innocence with the need to uphold victim dignity and legal certainty.
Hi, Ms. Umran. So, based on all these findings, what recommendations can actually be made?
There are 4 recommendations, and the first one would be the clearest statutory guidance on the meaning of consent would promote greater consistency in judicial decision making. A more precise legal definition would reduce ambiguity, and it also will assist judges in applying the law uniformly and limit the subjective interpretation that may vary from case to case. This will also provide clearer guidance for prosecutor and defense counsel when assessing whether consent was genuinely present. Second, many failed prosecution result from evidential weakness rather than genuine consent. Challenges such as delayed reporting, lack of physical evidence, and inconsistent witness testimony often undermine cases. Improving investigation method, strengthening forensic practices, and adopting trauma-informed interviewing techniques would help ensure that victim accounts are properly recorded and evaluated, thereby increasing the likelihood of successful prosecution. And third, continued judicial training on sexual violence dynamics would help prevent reliance on outdated assumptions. Training can improve understanding of victim behavior such as delayed or lack of physical resistance, which are often wrongly interpreted as indicators of consent. This will also promote fairer and more informed judicial reasoning. And finally, future research should include unreported cases to provide a fuller picture of how consent operates in practice, since a significant number of sexual offences go unreported. At the beginning, these cases would highlight systematic barriers to reporting and reveal gaps in legal protection that are not visible through reported cases alone.
In conclusion, this study shows that although the defense of consent is commonly raised in rape cases, it rarely succeeds under Malaysian criminal law. Malaysian courts adopt a strict approach, rejecting consent where it is vitiated by force, fear, deception, incapacity, or statutory protection. Where consent is accepted, it is usually due to evidential uncertainty rather than genuine agreement. Overall, this judicial approach reflects a growing awareness of the realities of sexual violence while maintaining core principles of criminal justice. Thank you for watching.